Welcome to this CPD session with Greens List. I'm told by some of my instructors that Greens List isn't one that you say to your secretary, ring up these lists and see who's available for family law. My clerk is out of the room, so I can say we don't really mind that, because we think that the specialism in family law on Greens List is fairly distinct in the commercial area, and probably a lot of the family law cases are ones that you wouldn't approach us for. But the more complicated commercial matters, the tax-driven matters, the trusts, are the areas that we feel the list has some expertise in. A base for all of that is, of course, understanding the procedural changes that exist. When you're arguing about children, you have the ability to look at the lesser adversarial methods, and people will graze across the regulations, as it were, to try and do the right thing for the child. When you're arguing about trust and tax issues, the procedural matters become much more important. Today's seminar is about recent developments in family law. We have had a raft of changes yet again, and indeed a much more complicated raft of changes, because you're still trying to work out what of them have been implemented and what of them haven't been implemented. We have two speakers today from Greens List. First of all, Richard Edmunds. Richard came to the bar in 1988. Like all of you, he had solid training as a solicitor in Gippsland before he came, and since coming to the bar he's been practising in the areas of family law, probate and general commercial litigation. He is a qualified mediator and mediates regularly in the family law area. At the other end of the spectrum, Anthony Berger accepted his first brief 7 days ago. Anthony has a background in tax and trusts, which is he's seen the light and appreciated that family lawyers are great people to work with, and indeed has 2 family law briefs already, he tells me. He's talking about some of the court procedural changes, but enough of me. I'd ask you to welcome Richard Edmunds.
Morning, everyone, and I'm not quite sure how loud that is. Thank you for being here this morning. It's cold, it's wet, it's dark. I got to deliver this paper the other week at the Southern Solicitors Conference up in Broadbeach, and what a change. People turned up in shorts, t-shirts and light dresses, not overcoats. I did this paper to address both the changes in respect of legislation and the Australian Law Reform Commission report. And when I started the paper, the Law Reform Commission report hadn't been released. It since has. If you can recall, our former Attorney General, the Honourable Senator George Brandis, in August 2007, perhaps as a bit of a swan song, he set in train a few matters, including engaging or appointing the Australian Law Reform Commission to review the Family Law Act. Pretty big step, and it is the first review since the commencement of the Act back in 1976. Terms of reference that the Attorney General set were broad, and wanted the Law Reform Commission to look at what were the changes or reforms necessary to the entire family law system, and look at in particular these matters: the appropriate, early and cost-effective resolution of all family law disputes, the protection of the best interests of children and their safety, family law services including but not limited to family dispute resolution services, family violence and child abuse, including protection for vulnerable witnesses, the best ways to inform decision makers about the interests of children and the views held by children in family law disputes, collaboration, coordination and integration between the family law system and other Commonwealth, state and territory systems, including family support services and family violence and child protection systems. Whether the adversarial court system offers the best way to support the safety of families and to resolve disputes in the best interests of children, and the opportunities for the less adversarial resolution of parenting and property disputes. To look at rules of procedure, rules of evidence that would best support high quality decision making in family law disputes, mechanisms for reviewing and appealing decisions, looking at families with complex needs, including where there's family violence, drug, alcohol, addiction or serious mental illness, looking at the underlying substantive rules and general legal principles relating to parenting and property, the skills including but not limited to legal required by professionals in the family law system, restriction on publication of court proceedings and improving the clarity and accessibility of law, and any other matters related to the terms of reference. So pretty broad. Really saying, have a look at the entire family law system as we know it. You've got open slather to make recommendations. There was a discussion paper that was circulated. I don't know if anyone here has read through it. I see a few nods. It was some 313 pages. It was published in October 2018 with closing submissions due by the 13th of November 2018. And the final report was tabled on the 10th of April 2019. So before going to what that report said, and perhaps noting that the following bits of legislation I'm about to take you to were all presented to the Parliament despite the fact that the Attorney-General had commissioned the Australian Law Reform Commission to look at significant changes to the Family Law Act, almost oblivious to its own appointment, the government went about putting up a whole raft of legislative change well before the Law Reform Commission was even going to put up a report. And you probably come across a lot of the material that was before both law bodies, the media, in relation to various legislative changes. A lot of submissions were made in relation to some of the bills, including the two bills that were the bill called the Federal Circuit and Family Court of Australia Bill 2018 and the Federal Circuit and Family Court of Australia Consequential Amendments and Transitional Provisions Bill 2018. Bit of a mouthful, but what it all related to was the court's merger. And some of you, no doubt, were involved in submissions relating to these proposed mergers and the change to the court system. Bear in mind, changes that were proposed well before the Law Reform Commission was even addressing these issues. These were announced in June of 2018, and it was intended that these changes would have taken place to commence on the 1st of January 2019. The major changes that you're probably familiar with were the merging of the two courts to create a brand new court called the Federal Circuit and Family Court of Australia. The significant changes were that there would be two divisions, Division 1, Division 2. Division 1 being the existing Family Court of Australia trial judges and their terms and conditions and their judicial pensions would remain the same. But there would be no further appointments of judges to that division. So the family court judges, as we know them, would eventually die out by attrition. And Division 2 would be the existing Federal Circuit Court of Australia. It would retain its family law and general jurisdiction. And the judges in that jurisdiction, their terms and conditions would remain the same. And interestingly, they don't receive access to judicial pensions. Now, it was also intended there be a single set of rules and forms for the new court, a single entry point for filing of applications and documents. And significantly, it was proposed that the appeal division of the Family Court of Australia would be abolished, and in its place you'd have one judge from the Federal Court of Australia who would hear family court appeals. A judge in the Federal Court who probably has never dealt with a family law matter in their life. And that was to be the new system. There were rather thick bills that were presented to the the Parliament, a rather detailed explanatory memorandum, a rush of applications, submissions from various law bodies and generally from the public in relation to the matter. And you had in February of this year the Senate Legal and Constitutional Affairs Committee releasing a report on the two bills, making 4 significant recommendations. The first one, interestingly, being that the courts have additional resources for registrars to deal with backlog of cases. It opposed the proposed change to the appellate division of the court, saying leave your appeal process as it is. A very interesting recommendation in respect of the qualification for judges. And it was to ensure that they have appropriate skills, knowledge, experience and personality. Some might say some of our judges have got a lot of personality. I don't know quite what they're driving at. Interestingly, and I'll come to this shortly, some of the appointments that were made involved judges who really had no family law experience whatsoever. So, go figure on that. The Australian government pursue an immediate appointment of suitable candidates to vacant judiciary positions in the family courts and consider whether there's a need to appoint additional judges. And subject to those changes, the recommendation was that the merger bill be passed. Now, you're probably aware it didn't get passed. That was because the Attorney General couldn't get the numbers to get it through, and rather than put it up and have it rejected, shelved it in the hope that they would get re-elected. When I did this paper, I didn't think that they were going to get elected. But then again, no one really took into account, I don't think, the outcome of the election and the significance that Queensland would play in it. So you have this recommendation from the Senate that the bill be passed. The government is toing and froing, thinking we don't quite have the numbers. The background to the legislation, you have other interested, if I call them stakeholders, expressing different views. One Nation, primarily from Queensland, made various noises way back in August of 2016 that the family court be abolished, be replaced with a family tribunal made up of people from mainstream Australia and respected members of the local community, and that social and health groups would be invited to participate. And then in February of 2019, at the time that the Senate committee is looking at its recommendations, you have Pauline Hanson of One Nation jumping on the bandwagon and saying there ought to be a royal commission into, as she said it, the family law. In the lead up to the election, oddly enough, another Queenslander, Clive Palmer, also pushed for a royal commission into family law. Oddly enough, both the Liberal National parties, the Labor Party, rejected that when Parliament was still sitting. Now, coincidentally, I noted that there was a spate of judicial appointments straight after the Senate recommendations. And at the back of the paper, I've attached a schedule of all of those various appointments. And some of them in Melbourne I've highlighted just for my notes. Going back to October of 2017, you had now His Honour and now Chief Justice William Ostergren, QC, who was appointed as a Chief Judge of the Federal Circuit Court of Australia, and also a Justice of the Family Court of Australia. And then he's subsequently appointed on the 10th of December 2018 as Chief Justice of the Family Court of Australia and Chief Judge of the Federal Court of Australia. He's a Victorian, but he, some might say, didn't have a background in family law, so it was a very interesting appointment. In January of 2018, Ms. Caroline Curtin QC, who has a commercial background, was appointed as a Judge of the Federal Circuit Court of Australia. The 11th of March 2019, and this is shortly after the Senate recommendation, you have Joshua Wilson appointed as a Judge of the Federal Court of Australia. Sorry, from the Federal Court of Australia to the Family Court of Australia at Melbourne. You have Ms. Anna Boymel, who was formerly a Registrar of the Family Court of Australia and a well-experienced family law barrister, appointed to the Federal Circuit Court of Australia. You had in March 2019, Dr. Timothy McAvoy QC appointed as a Judge to the Family Court of Australia. And you also had Ms. Alice Carter appointed as a Judge to the Federal Circuit Court of Australia. And later in March, Judge Nora Hartnett from the Federal Circuit Court of Australia was elevated to the Family Court of Australia. So you could see that there was a rush of appointments, and interstate, similarly, a large number of new appointments. So the government was taking seriously the recommendation to have new judges appointed, and in the lead up to the election, the Attorney General had made some public statements that changes to the Family Law Act, the merger bills, were matters which were, quote, matters we would absolutely be committed to. So, although it didn't get through, it's still back on the agenda. Who knows what the role of One Nation might be in relation to family law in the future? As I said before, don't underestimate the Queenslanders. They do seem to have a bit of a input. And just recently, in relation to the proposed passage of government legislation in the new Parliament, particularly in relation to tax legislation, I did hear Senator Hanson in one of those short grabs state, we've got more important issues to look at, including matters relating to family law in Australia. So who knows what barrow she'll be pushing to get her votes in relation to tax legislation across the line. So that's the court's merger bill. There was another bill that in fact got passed as referred to as the Family Law Amendment, Family Violence and Other Measures Act 2018. It received royal assent on the 31st of August 2018 and commenced on the 1st of September 2018. And I actually tried to Google on the Austlii site to see where this new act was and couldn't actually find it. It's merged as an amendment into provisions of the Family Law Act, but I actually found the act by going to the government legislation website, and from it you can see that some of the new changes, there's a new section 69GA in the Family Law Act which will give prescribed state and territory courts powers to deal with matters basically in the same way as courts of summary jurisdiction would hear matters. There's a new 69ZL which empowers a court to give short reasons for decisions in relation to interim parenting. In relation to section 45 capital A of the Act, that is an amendment that provides the court with power to make summary decrees for summary dismissal of proceedings. In the event that court is of the view that there's no reasonable prospect of successfully defending or prosecuting a claim. And it can dismiss a proceeding at any stage if it's satisfied that the proceeding is frivolous, vexatious or an abusive process. And it can make such cost orders as it sees fit. It actually repealed section 118 of the Act relating to powers to dismiss frivolous or vexatious proceedings. So it actually has set in train a specific area that deals with summary dismissal of proceedings, even though there was power to dismiss. There was a recommendation, or in the bill, a proposal in respect of penalties for breaching of injunctions that did not find its way into the new legislation, and that was to impose a penalty of imprisonment of up to 2 years or 120 penalty units if a respondent's found to have breached an injunction under section 68B or section 114 that was expressed to be for the protection of another person. So I'm not quite sure why they didn't go that step further, but there isn't that penal provision or that monetary penalty provision. An interesting bill that hasn't been passed yet, Family Law Amendment Parenting Management Hearings Bill 2017. For those who are looking at some form of career change in life and looking at being involved in a decision-making process, there may be an opportunity for you, if this legislation gets through, to sit on a panel to determine matters relating to less complex family law parenting disputes, disputes involving self-represented litigants. And this bill is clearly aimed at trying to take away from, I guess, the backlog of cases that are swamping the court in relation to children's matters and self-represented litigants, and set up a separate panel to determine children's issues. It's a fairly serious intent of the government to establish this panel. It actually already allocated in its budgets $12.7 million in funding over the next 4 years to establish and operate this panel. So what's this panel going to be comprised of? There will be a principal member who has to have legal experience, be admitted to practice as a practitioner of the High Court or Supreme Court of a state or territory, and at least 5 years' experience, and extensive knowledge in family law matters relating to both family law and family violence. And then there's a raft of other members on this panel who will sit to determine children's matters. And the qualifications proposed are that they must have at least 5 years' experience working with families and children, and they can have specialist knowledge in any of the following fields: psychology, counselling, social work, family dispute resolution, community work, family violence, mental health, drug or alcohol addiction, child development, or any other field relevant to the duties of a panel member. And those panel members would be appointed for periods not exceeding 5 years. The types of applications that would go before the panel would be applications brought by either a parent of a child, the child themselves, a grandparent of the child, or any other person concerned with the care, welfare and development of the child. And in respect of what they call parent management hearings, they cannot proceed unless there is consent in writing from each person who has parental responsibility for the child. And if there's an existing parenting determination or parenting order from the person in favour or in whose favour that order is made. Who can represent you or the parties in this proceeding? Bear in mind it's set up to deal with self-represented litigants. So if you've got parties appearing before this panel, they can be legally represented, but only with leave from the panel. And when the panel considers whether to grant leave, it will consider whether or not there are reasonable grounds to believe that there's family violence by a party to the hearing or risk of family violence, and whether the person who, or one of the parties attending who is seeking to be represented, has effectively capacity to effectively participate in that hearing without legal representation. And if legal representation is granted, the panel can actually give guidelines or directions as to the role, the extent that that legal representation will involve. A party may have a person assist them at the panel who is a non-lawyer, but that non-lawyer is not allowed to present arguments to the panel unless the panel considers there are exceptional circumstances. The panel can seek welfare reports. It can refer parties at any time in the proceeding to various services such as family counselling or family dispute resolution or other family services. It's got power to seek to obtain documents. And then there are sections in the proposed bill relating to allegations of family violence and child abuse, and there has to be notification to the panel if there are existing family violence orders, or in the event that if there's a family violence order, the panel must be notified of that order. And if the panel has a suspicion, reasonable grounds for suspecting a child has been abused or at risk of abuse or ill-treated, the panel may notify a child welfare authority of that concern. If a family violence order is made subsequent to a parenting decision of this panel, to the extent that the family violence order is inconsistent with the determination of the panel, the determination will prevail. And in relation to matters which cannot proceed before the panel, so it's not given carte blanche to hear everything. It cannot hear matters where the written consent isn't provided, matters involving relocation of a child, matters where the application itself alleges sexual abuse or risk of sexual abuse, where a child is under the care of a person under child welfare law, where a final parenting determination is in force unless there's a significant change that the panel is satisfied in relation to the circumstances of the child. Can't hear it where there are proceedings that have been instituted in a court unless a court actually refers the matter to the panel. When a parenting order is in force, again, unless there's been significant change. Where there's a registered parenting plan, a registered overseas child order. If all parties ask the application be dismissed, and taking into account the concerns of the government as to costs of matters, in the event that the parenting management hearing fee has not been paid. And there's a provision in the legislation that the application must be dismissed if it appears to the panel a court or authority under child welfare law proposes to make an order or take action by which a child is placed under care under a child welfare law. And there's a range of matters that are set out as to what sort of determinations this panel can make. And it can make determinations relating to shared parental responsibility, no need to consult on issues that are not long-term major issues, equal time or substantial and significant time, interaction with parenting plans, obligations created by parenting determinations. And there is a penalty provision of 3 years imprisonment in respect of a party taking their child out of Australia contrary to a parenting determination, and certain penalties imposed in respect of captains of aircrafts or ships taking people out of Australia. The parenting determination reasons may be made orally or in writing, and then if they're not made in writing, you can make a request for the written decisions, and they've got to be provided in 28 days. And appeals are limited to questions of law to be made to the Federal Circuit Court of Australia within 28 days. So that's the new panel to deal with children's matters with self-represented litigants. And then the Act provides that after 3 years, it's to be reviewed, presumably to see if it works. There's another Act that's been passed. In the paper it's referred to as a bill, but it's actually passed as an Act. Family Law Amendment, Family Violence and Cross-Examination of Parties Act 2018. And that received royal assent on the 10th of December 2018, commenced on 10th of March this year. And it relates to cross-examination of parties where there are issues of family violence. And it was stated to apply to cross-examinations that occur 6 months after the commencement of the Act. So from the 10th of September this year, this Act will actually be in force. The reason for that was to give parties involved in the process time to understand the application of the Act and applications for retention of legal practitioners. So the major effect of this new Act is that in proceedings where a party wants to cross-examine another party and there's allegations of family violence and either party has been convicted or charged with an offence involving violence or threat of violence to the other party, or a family violence order applies to the parties, or there's an injunction under Section 68B or Section 114 for the personal protection, of the other party, or the court makes an order that's to apply in respect of cross-examination, then the following applies. The examining party must not cross-examine the other witness party personally. That cross-examination must be conducted by a legal practitioner on behalf of the examining party. So this opens up another range of work for you as practitioners in this area. Court can make an order on its own initiative or on the application of a witness party or the examining party or an independent children's lawyer if appointed. And there's also a system to be put in place in respect of the information that's to be provided to unrepresented parties relating to this legislation. And there will be assistance provided through the Legal Aid Commission of the States and Territories. Application should be made within, well, as soon as it's referred to the Legal Aid Commission, they've got some 6 weeks to confirm the appointment of a lawyer allocated. Parties who will be getting assistance under this scheme, the scheme will not be means tested or merit tested, but they may be required to make financial contributions to the cost of their legal representation. And if for some reason they are no longer represented under the scheme, either by a private lawyer or a Legal Aid Commission appointed lawyer, then the cross-examination ban continues and they cannot cross-examine. So those are the legislative changes. And bear in mind, when I started the presentation, I mentioned that the Law Reform Commission presented its report on the 10th of April of this year. And I've attached at the back of the paper the recommendations, and I just want to flick through some of the significant recommended changes. So if you've got your seatbelts well and truly buckled, be ready for a brave new world if these changes subsequently become part of government legislation. A new court structure. First recommendation was the Australian Government should consider options to establish state and territory family courts in all states and territories to exercise jurisdiction concurrently under the Family Law Act, as well as state and territory child protection and family violence jurisdictions, whilst also considering the most efficient manner to eventually abolish first instance federal family courts. Bit of a change. Then it went through matters in relation to changes to the Family Law Act, recommended that Section 60 capital B of the Act be abolished, which sets out effectively how you determine what are the best interests of the child, and sought to effectively readdress those under a new Section 60cc as to what the best interests of a child should be. And that's in respect of parenting determinations, what promotes the best interests of a child. And in summary, what arrangements best promote the safety of the child and the child's carer, including protection from family violence, abuse or other harm, any relevant views expressed by the child, the developmental, psychological and emotional needs of the child, benefit of the child being able to maintain relationships with each parent and other people who are significant to the child, where it is safe to do so, the capacity for each proposed carer of the child to provide for long-term developmental, psychological and emotional needs of the child, having regard to the carer's ability and willingness to seek support to assist with caring, and anything else relevant. There's a recommendation to replace the presumption of equal shared parental responsibility with a presumption of joint decision-making about major long-term issues. don't know if it's just a matter of pedantry, but also recommends that the Section 65DAA, which requires a court to consider possibility of a child spending equal time or significant and substantial time with each parent, should be repealed. Recommends that in respect of property proceedings, it should be simple. The Act should specify the steps that would be required to alter an interest in parties' property, and simplify the list of matters the court may take into account when considering whether to make an order to alter the interests of parties in relation to property. But it doesn't actually then go that step further to say, and these are the recommended simplified steps. It does say that there should be enshrined in the Act a presumption of equality of contributions during a relationship. That, and this is very interesting, significant change when dealing with adjusting interests of parties in property. The value of the property should be looked at as the value at the date the parties separated, unless the interests of justice require otherwise. And as you're all aware, at the moment, the court looks at the value of the property at the date of trial. Recommendation for some protocol dealing with issues of debts of parties and proceedings in relation to enforceability of debts to be determined and dealt with under the National Consumer Credit Protection Act, and disputes in respect of reallocation of debts to parties under the Family Law Act. Peter, how long have we got?
A wise thing to draw your comments to an end.
Okay. Now, bearing in mind time, and I also thank Peter for being here because I'm conscious that he also has a very complicated trial he's been involved in that he has to disappear at about 8:30 or earlier. I will wrap up shortly. I'll just simply say the recommendations of the Australian Law Reform Commission are attached to the paper. Two issues I just want to mention. In respect of superannuation, a legislative change to have a presumption of the value of superannuation being acquired during a relationship to be split evenly. And in respect of a new area of claims in respect of damages under the Family Law Act, the recommendation is that there be a new statutory tort of family violence that would provide remedies consistent with existing common law claims such as damages. So be aware. Thank you.
Thank you, Richard. If that is what is in line for us, and some of that has already come into practice, the issue now is what practical changes are there that we have to be aware of. Anthony?
Yes, always bearing in mind that they could just remove the whole court tomorrow with a new one and we'll need a new set of rules. I just want to gauge the room first. We'll cast a wide net. How many of you have drafted an affidavit? How many of you have used a notice of risk form? How many of you have been involved in judicial mediations? A bit less. Application for leave to appeal to the family court? Very few. All right, in that case, this is all going to be quite relevant and applicable because the rules have all changed a bit in the last 2 years and some new practice directions have come out. So I'm going to go in the order of the paper, starting from page 17. So the court files are now digital. That is, if they make one. If they don't make a digital court file, it's the paper file. Just a technical matter. Regarding the rules for affidavits, filing and serving them, you now don't attach annexures and exhibits. You do not file annexures and exhibits. You identify them in the document and you serve hard copies of them. So technical as well, but practically what it means is when you bring them, you need to bring them to court. You don't file them with the court originally. The notice of risk forms have been split into two. There's one where you've got a live case and there's one where you're seeking consent orders. The difference in them is the current case form requires you to identify which paragraphs detail the abuse, whereas the consent orders form requires you to go into some detail about how the proposed orders address the risk of family violence. So the form draws your attention to this. There are very slight differences. Point 3 on the paper. If you're applying for consent orders relating to a de facto relationship, you don't need to do a superannuation information form anymore. It's just proof of value. You just demonstrate that. I sought some guidance on that. It looks like for the vanilla case, it's just going to be the balance statement would be the proof of the value, sufficient for that section. In the event of appeals, you've now got submitting notices, which are essentially, if you don't disagree with what's being proposed, you nonetheless need to file this to submit to the jurisdiction. The paper goes into a bit more detail there. You've now got notices of contention, which is where you're contesting an appeal, but you want to uphold the original decision for grounds extra to the original decision. So you get to have your cake and eat it too, as it were. You get a second go at defending it. Last one is about undertakings as to damages. If you make an oral one, you need to put it in writing and within 14 days have it filed and served. The rule goes on to define what an undertaking as damages is, but effectively it's submitting to an order for payment of compensation. So it's giving it a bit more court authority there. How many of you have filed a response? Cool, you've got 28 days now, no longer 14. Now, in the interim proceedings, interim applications, the important one is that affidavits are now limited to a maximum of 10 pages. I've heard anecdotally that one judge has, in receipt of a lengthy affidavit, has read the first 10 pages and stopped there. The practice direction does say that the judge has that discretion. Alternatively, you may select which 10 pages you want the judge to read. Best to avoid all that, limit it to 10 pages, and you're also given 5 annexures as a maximum. You can seek leave. I'm not sure how difficult that one's going to be, but judges are pretty tight on this rule, it seems. You've got judicial mediations. This is to be used where the direction says where practitioners and parties will exhaust all mediation alternatives prior to this. You can get into one of these via an oral application or written to the docket judge in chambers. Again, the direction sets out all the procedural matters. You've got 14 days, the docket judge can make procedural orders. Importantly for you is that the legal reps need to have the full authority of the parties to settle the proceeding, so you can't go into one unless you've got that. And the preparation that's required is set out in the practice direction, but generally it's a list of all of the documents that have been filed in this proceeding, case summary, paginated court book. In property matters, copies of valuations of assets. You basically need to be prepared as if it's a court matter, but it's done as a mediation. As for leaves to appeal, this is only after the 2nd of April this year, so relatively new. They've set it up so that the application for appeal can be heard with the appeal or otherwise separately, and if the application is to be heard separately, you don't need to file appeal books until leave is granted. And your summary of argument is limited to 5 pages, although that might be a matter for counsel. Cool. Those are all of the current changes, but yeah, as we can note, the jurisdiction is possibly about to be toppled and replaced. Thanks.
Thank you very much. The opportunity now exists for questions or relevant comments. Another function of coming along is hearing the benefit, or having the benefits of hearing others about their experiences, either informally over a cup of coffee, or there may be an observation which you might like to make. Obviously, someone's happy to. We have a microphone.
Just in regards to not attaching affidavits, annexures to affidavits and filing them online and bringing them to the court and handing them up, is that for both the Federal Circuit Court and the Family Court?
The affidavits in the Family Court of Australia are not to have exhibits attached to them. Federal Circuit.
Yeah, that's what I thought. I just wanted to clarify that. Thanks.
I think one of the changes, however, is that we used to say document annexed here to and marked X says whatever. Increasingly, you're going to have to excise out the relevant quote from a letter or document and insert it into your affidavit. Otherwise, the judge reading it doesn't make any sense.
I also say in relation to affidavits in the Family Court of Australia, approached by the judges is to say, well, we haven't seen any of these exhibits, and just present to us the ones that are now irrelevant. So you don't have to go through an affidavit if the exhibits are done.
I perhaps pose A, make a comment, and B, pose a question. First of all, I'm interested in Mitchell's view. The change to the cross-examination rules, I think, opens up some of the material from the Royal Commission relating to vulnerable witnesses. And we've seen, particularly in the sexual assault area, the use of safe rooms and other procedures for people to give evidence. Be interested in Richard's view as to whether that will now increasingly move into family law. But if it does, that's a very positive recent experience with it. One of the problems will be moving those rooms. The OPP has 3. There's one at the Berger Justice Centre. There are 2 at the County Court, but they are all very heavily booked. And so if you're thinking of trying to use that facility, you need to have it well planned in advance, because the court expects you to set up the video link for the vulnerable witness client. Richard, comments on that sort of system over here?
Subject to, as Peter mentioned, the availability of facilities to do so, the amending provision under section 102N, that Act provides the court must ensure during cross-examination there are appropriate protections for the party who's the alleged victim of that violence, and that may well involve, and denoted in that section says, the court may consider it appropriate to give a direction that cross-examination be conducted by video link or audio link. So, if there is a cross-examination and you've got a concern that the party should not be in the same room, particularly if there's been significant family violence, we would ask the court to try and do that beforehand through the associate registry to make that arrangement available. Do you have any other questions before I pose one? Didn't touch on arbitration, Nick. Yes, I didn't touch on it. It's in the paper in respect of the recommendations of the Australian Law Reform Commission. You recall I mentioned that there's a new scope of work available for lawyers in respect of being a lawyer for a party represented by, self-represented party, or in respect of cross-examination of witnesses. There's also a role in respect of arbitration. The recommendation of the Australian Law Reform Commission, is recommendation number 26, is to have disputes arbitrated, whether by referral by court or otherwise. And they could be both financial matters and child maintenance and child support matters. Won't include matters related to enforcement or applications under Section 79A or Section 90N, or matters involving where a litigation guardian is appointed. And in respect of children's matters, arbitrations would not include matters relating to international relocation, matters involving medical procedures requiring approval, contravention matters, proceedings where an independent children's lawyer is appointed, or certain matters involving family violence under Section 2 of the Cross-Examination of Parties. So there are significant proposed changes to expand the scope of how decisions can be made in family proceedings. Bear in mind, if there's an arbitration, the arbitration has to deliver an arbitral award.
Hi, I've heard a rumour that they want to implement a system of pre-litigation mediation in property matters. Have you heard anything about that?
The current
Compulsory
legislation, you're probably aware that there are pre-action procedures parties are supposed to comply with. I'm never sure if anyone complains these days about non-compliance with pre-action procedures, but a recommendation in respect of property matters is that there be effectively a pre-action attempt to try and sort out property matters, and that you need a certificate of compliance to be filed before you commence the property proceeding. That's the recommendation. Question down in front.
In view of the recommendations about those panels for children's matters, what happens when there is children's plus property, complicated property? Does that mean, currently obviously you can run the two at the same time in court, but if you have those panels, does that mean there's going to be two sets of procedures and complicate things, or what's envisaged in terms of...
As I understood it related to resolving disputes between self-represented litigants in respect of parenting matters. So I suppose there are property matters, they have to be dealt with separately. In fact, it's referred to as the parenting management matters.
One of the parties that we can get one decision. Then it goes through the court.
The issue, of course, is that we are speculating on what the final form of the legislation will be. But to say that the trend in government thinking and indeed in the law itself to simplify children's issues and to separate property is probably the way things seem to be going. Whether there are amendments to the Act as it currently stands which enforce that, or whether as the Act currently stands which merely creates a mechanism primarily for self-represented people, we'll have to wait and see what the
And just following up on that, with respect to the parties who would appear before this panel, that's in the form of the legislation as proposed, it is for self-represented litigants, and the panel has the power to direct that a party could be represented in certain circumstances.
Have any final question? Thank you all for your attendance this morning. Feel free to detach the speakers and have a chat outside and enjoy the rest of your day.